Thanks everybody for letting me be part of your conference today. I really appreciate it. I had this horrible thought this morning. It woke me up from a deep sleep. I thought, oh my God, do I have to wear long pants? So I came downstairs and checked the camera angles, and sure the answer was no, I didn't have to, but it's kind of funny how life has changed over the past few months. So this presentation, I first did a version of this last year. I was thinking of different ways that I could get out and make people talk about, think about, or at least hear about diversity and inclusion, because I do firmly, truly believe with all my heart that the lack of diversity, inclusion, equity, fairness in our profession is the most important issue that we face. And I think the same thing is true with our society as a whole, but I'll be happy if I can tackle the legal profession. And so I think that it's important, especially when you think about the role that implicit bias plays. It's important, if nothing else, to make people think about it and to keep it at the top of their minds. And I've tried to do that in many, many different ways over the past years. And so I sat down to do a presentation. I'm also a legal ethics professor, and I love legal ethics. And I looked around and I didn't find any presentations at that time on legal ethics of diversity and inclusion. Since this, a few months ago, another National Bar Association member, David Douglas, did a great presentation on this topic. It is very different than this one, but it was wonderful. And I'm actually going to tell you about a couple of things that he said in his presentation today, but I'll jump right in here. And I hope you're seeing the slides on the screen. I have this thing never works the first time, so I have to, one manual click here. Okay, so why do I think this is such an important issue? And the reason, among other things, is that even though lawyers in the legal profession, we're the ones charged with doing justice in the world, or facilitating the doing of justice, our profession may be the least diverse of all professions. I'm not sure that it actually ranks last, but it ranks close enough to last to be disturbing. And just for some examples, African-American lawyers, Hispanic American lawyers are disproportionately underrepresented. Asian American lawyers are relatively proportionally represented in the profession overall, but they have the highest attrition rate of any identifiable group. Women are about half of all law school graduates, but only 18% of equity partners. We have decades of studies showing us that diversity and inclusion and fairness and equity are good for everyone. They're good for the lawyers, they're good for the law firms, they're good for the associates, they're good for the clients. And yet we've had decades of initiatives that have failed to get the job done. We have made progress, yes, over the past 30 to 50 years, but we're not getting where we need to be. And yet, despite all that, the prevailing response that I find among my colleagues is, we're doing all we can, it's just going to take some time. So the question I ask is, will time fix this problem? Is it going to go away by itself? And the numbers indicate not. I pulled these numbers from the ABA Lawyer Population Survey, but there are similar numbers all over the internet if you look. Comparing 2019, which was the most recent numbers at the time I did this, with 10 years earlier, 2009. If time is going to take care of this, you would expect to see some dramatic changes over that 10-year period. But look at the numbers. Female overall attorneys, the percentage of attorneys who are female went up from 31 to 36%, which is at least progress. Number of attorneys who are African American, the percentage of attorneys who are African American, 5% 10 years ago, 5% now. The percentage of attorneys who are Hispanic American, 5% then, 5% now. And that's after a rally. The percentage of lawyers who are Hispanic American had actually dipped to 3% during that 10-year time period. These numbers do not indicate that things are going to get better on their own. And I think that it's incumbent upon each and every one of us to do what we can to make the numbers change, not just the numbers, but make the culture change. And I think the culture change actually has to come along with, if not before, the number change. We have to make this a place worth being before we can get people to come here. There's some other stuff that sort of says the same kinds of things in a different way. This ABA Commission on Women in the Profession found that women are almost half of summer associates and associates. I think they may actually be half now. but they're only 22% of partners and 18 to 19% of equity partners, depending on which report you see. Now purports that Asian American lawyers make up 9.3% of law firm associates, but only 2.2% of law firm partners. And I saw another report that was actually commissioned by an Asian American judge in California that found that Asian Americans have the lowest partner to associate ratio of any identifiable group. Something is happening along the way, and I think that we have to accept that something that's happening is something that we're doing, whether we intend to do it or not, and that we need to stop doing something we need to fix. So the American Bar Association has made some efforts in this area. They started back in 1986 when they adopted a goal to promote full and equal participation in the profession by minorities and women. And then in 2008, they adopted another goal to eliminate bias and enhance diversity. In 2012, the ABA president formed a task force on gender equity to focus mainly on pay equity. And then in 2016, the ABA finally adopted a model rule that generates ethical implications for people engaging in discriminatory conduct. Now, before this, in 1998, the ABA had adopted a comment 3, that I'll show you here in just a minute. But this was actually the first time that in a model rule, we addressed the ethical implications of discrimination. So here was the old comment 3 that was first put in 1998. It was comment 2 at the time. It became comment 3 later. And it says, a lawyer who, in the course of representing a client, and that's an important limitation, knowingly, that's another important limitation, manifests by words or conduct bias or prejudice based on race, sex, religion, or any other protected status, violates this paragraph when such actions are prejudicial to the administration of justice. And David Douglas in his presentation asks the question, when is discrimination, bias, and prejudice not prejudicial to the administration of justice? I think that the two things are incompatible. And then it goes on to clarify that legitimate advocacy respecting the foregoing factors does not violate paragraph D. So if you're representing a company that's being sued for some form of discrimination, you can represent them without facing an ethics challenge. This is not broad. I mean, this is a fairly narrow comment and not even a rule. Now here's Model Rule 8.4G that was adopted again in 2016 after much debate, much debate. It is misconduct to engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, other protected statuses. This is actually a broader range of protected statuses than was in the comment before. And then it ends with, that is in conduct related to the practice of law. That's the limitation. That's when are lawyers subject to this rule. It's when they're engaged in conduct related to the practice of law, which is going to be defined here in just a second. So here are the types of conduct that the comment says the rule is intended to address. Starts out saying discrimination and harassment by lawyers in violation of paragraph G undermine confidence in the legal profession and the legal system. And I think that's right. People expect us as lawyers to do the right thing. And when we don't do the right thing, when we do something that is so grossly wrong, it undermines confidence in us as a profession. And the kinds of discrimination that they're talking about, they say, include harmful verbal or physical conduct that manifests bias or prejudice towards others. Harassment includes sexual harassment and derogatory or demeaning verbal or physical conduct, unwelcome sexual advances, requests for sexual favors, other unwelcome verbal or physical conduct of a sexual nature. And then it says the substantive law on these things can guide the application of the paragraph. That is not, that's not digging into people's lives. I mean, that is mostly focused on, outward blatant manifestations of bias and prejudice and physical conduct, engaging in improper physical contact with people. And I watched videos of the speakers when this rule was finally adopted, the proponents of it, and the the opponents of it, explaining how they had resolved their differences. And they kept emphasizing how we're really talking here about, you know, grabbing somebody's body parts at a party, or just outwardly manifesting bias and prejudice in ways that nobody would ever find acceptable, that I think would have been violations of the rules before this. I think that the kind of conduct would have been deemed prejudicial to the administration of justice even without the rule. Nevertheless, there has been, wait a minute, sorry. So here's the limitation: conduct related to the practice of law. When does this rule apply? And it's when you would think of yourself, you're out being a lawyer. It's when you're representing clients, interacting with witnesses, co-workers, court personnel, lawyers, people like that, when you're operating or managing your law practice, or when you're participating in bar association business or social activities in connection with the practice of law. So even if you're not at your law firm or at a courthouse or even at a bar meeting, if you're out at some activity where you are there as a lawyer, presenting yourself and holding yourself out as a lawyer, then you're governed by the rules. That's what comment 4 says. That's relatively broad area, and that's where a lot of the dissent comes in. So despite the fact that this rule is not really digging into people's lives much, from my perspective, there was a lot of opposition to it. And a lot of this opposition that you see here is the same opposition that comes out anytime we talk about a rule that will address access to justice, or we talk about bar associations facilitating access to justice, or we talk about diversity and inclusion. The same objections always come up. They say they're unconstitutional speech codes for attorneys, and always going to be some kind of a trap. If a lawyer says something that they intend perfectly innocently, they'll be subject to ethical violations. And I would just say that kind of thing could happen with any rule. We just have to make sure that the rules are properly enforced. They say it's an unconstitutional form of viewpoint discrimination by punishing people who don't support or believe in affirmative action, alleged systemic prejudice, that's their words, not mine, implicit bias, and so forth. They say it infringes on the free exercise of religion and freedom of association rights. It adopts a specific philosophical viewpoint. And it says bar associations do not exist to promote specific ideologies and lack the power to do so. Stopping right there, this is exactly what codes of ethics do. They adopt viewpoints. They draw lines between conduct that lawyers won't do and conduct that lawyers will do. They tell us what it is that makes us a lawyer, what conduct is consistent with being a lawyer. Every one of the rules does that. You can go through the entire rule book, and for each one, you can come up with a reason why, you know, I can say I should be able to represent clients who have conflicts with other parties. I should be able to represent, as long as my client wants me to do it, and I can do a good job. But the rule makers decided that there are certain kinds of conflict situations that even if the lawyer's okay with it, even if the clients are okay with it, it just can't be done. You can't represent both sides in a lawsuit because it just looks so bad. It is not consistent with the view of the legal profession that we are trying to convey to our constituents, our fellow members of society. Do it all the time. And yet, when it's a philosophical viewpoint that people disagree with, they oppose it. And then one comment was, not every lawyer wants to be a hero. Some simply want to be attorneys. And I would say this rule is not asking anyone to be a hero. It's asking you to be a lawyer. Someone who, who advances justice and fairness and equality. Another one that they always say is that it's taking a position on a partisan issue. And I say, is there really a party that says equality is bad? I mean, that officially says that equality is bad. You may think that some parties believe that. Is there really a party that says poor people aren't entitled to lawyers? Is there really such a party? If there is such a party, I think it's perfectly appropriate for our rules of ethics to say that it's inappropriate for lawyers to espouse the views of that party. These people were not upset back in the days when communists were the bad guys, and there were bars would impose rules saying you couldn't be a member of the Communist Party or couldn't espouse the views of the Communist Party. But this really very benign language in the rules, just saying you can't discriminate against people, You can't be biased and prejudiced, at least outwardly, generates a lot of opposition. But 8.4G did pass the American Bar Association. So what are we talking about when operating or managing a law firm or law practice? It is now, if a jurisdiction has adopted the model rule 8.4G, it would be an ethical violation to discriminate in hiring or promoting while operating or managing a law practice. I think that would have been an ethical violation anyway. It's illegal, but it is now specifically made an ethical violation, and it in theory creates an ethical responsibility to diversify at the associate partner level. I don't think it is being treated as that, but that's what it does in theory, and that's what it should do. And then you can still engage in conduct undertaken to promote diversity and inclusion. So what we're doing here today, we wouldn't be committing an ethical violation by saying something that some white person might think is discriminatory. As long as you're doing stuff legitimately focused on diversity and inclusion, you're fine. And you can do things like implement diversity and inclusion initiatives. You can sponsor and support diverse law student organizations. You can limit the scope or subject matter of a practice to serving members of underserved populations. All that stuff is fine. That's not what the rule is addressed, is intended to address. So what's happened? The American Bar Association, the model rules of professional conduct don't govern any of us. They are recommendations for other people to adopt. Well, there are 35 states and DC that have some form of anti-discrimination rules or comments, some form. Many of them just have the old model rule comment 3 or something along those lines. 22 states and DC have narrow anti-discrimination rules that are based on the old model rule 8.4D comments. 15 states have broader anti-discrimination rules with language more like this new 8.4G. Here's the different protected categories by state. Which states protect which categories? And almost everybody, obviously, race, sex, so forth. They really have no choice but to protect those things, because to be protected under other law anyway. But 34 states and DC protect sexual orientation or sexual preference and so forth. I won't go through all of those. Only 2 states have adopted model rule 8.4G and comment 4, defining conduct related to the practice of law. And the states that haven't adopted it, they have not adopted it because they think it's too broad. Like the Bar Association, they think that going into what people are members of and meetings that they go to when they're not actively practicing law is just too broad. Vermont, not surprisingly, adopted comment 4 in its entirety. Vermont is on board. Maine took out the part about bar associations, business, and social activities. And many other states have just refused to adopt comment 4 at all because of concerns that the rules would chill First Amendment speech. I struggle to think what First Amendment speech would legitimately be chilled by these rules. I do not think these rules were intended, nor do I think that they would be applied to somebody who's legitimately debating. Affirmative action was the example somebody gave earlier. I think we encourage people to debate. We encourage lawyers to think things through and to help others think things through. That's what we do as lawyers, and I respect those people. I will defend their right to make sure that these views are fleshed out. But that's not what this is about. So most states now only apply their anti-discrimination rules, whatever it is, whether it's the old narrow rule or the newer, somewhat broader rule, when a lawyer is in the course of representing a client. So when you are doing something for your client, you're in court, you're talking to your client, you're out interviewing witnesses, under those circumstances, or you're running a law firm, I guess, the ethical rules apply in those states. Like DC, the ethical rule regarding discrimination applies only in conditions of employment, which seems to me would be a violation of Title VII of the DC Human Rights Act anyway, but that's very narrow. Massachusetts says, while appearing in professional capacity before a tribunal, so only when you're actually in court or in an arbitration proceeding. Arkansas and Florida, it's broader, duties in connection with the practice of law. These states require a formal determination by a judicial tribunal or they require that there actually have been a violation of federal, state, or local anti-discrimination laws. California, Illinois, Minnesota, New York, and Washington. Some states have vehemently rejected the Model Rule 8.4G and Comment 4. The Montana legislature passed a joint resolution stating that it violates the First Amendment and seeks to destroy the bedrock foundations and traditions of American independent thought, speech, and action. You guys saw the rule. The Montana legislature says that it's undermining our entire way of life. Texas Attorney General said that it would severely restrict attorneys' ability to engage in meaningful debate on a range of important social and political issues, including subjecting participants in candid dialogue on topics such as illegal immigration and same-sex marriage to discipline while suppressing their thoughtful and complete exchanges about those complex issues. Louisiana's Attorney General said that the expansive phrase conduct related to the practice of law is unconstitutionally broad as it prohibits and chills a substantial amount of constitutionally protected speech. I think all those are wrong, but you see the problem. Just getting 8.4G passed anywhere, this is the kind of opposition that was generated, and it hasn't passed most places. It's only passed as written in 2 places. It doesn't give you a lot of reason for hope about doing something that's actually meaningful. So the Virginia State Bar, just look at a couple of different jurisdictions. Virginia State Bar has not adopted any rule on diversity and inclusion or discrimination. It hasn't adopted any part of 8.4G or Comment 4. And in the commentary to its rule specifically notes that it declined to adopt the old Comment 3, the narrower version of it. But the Virginia State Bar, Virginia judges are subject to the canons of judicial conduct, which do include a lot of this stuff and even more. Canon 2C, for example, of the Virginia Canons of Judicial Conduct says that a judge shall not hold membership in any organization that practices invidious discrimination on the basis of race, sex, religion, or national origin. And the commentary says that public manifestation by a judge of the judge's knowing approval of invidious discrimination on any basis gives the appearance of impropriety under Canon 2 and diminishes public confidence in the integrity and impartiality of the judiciary in violation of Section 2A. And I'm not sure why that is the rule with respect to judges, but not with respect to lawyers. If it's true with respect to judges, I think it would be true with respect to lawyers, at least as true with respect to lawyers. So the canons of judicial conduct go on and say a judge has to perform judicial duties without bias or prejudice. A judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice, including but not limited to bias or prejudice on basis of race, sex, religion, other protected categories. And the judge shall not permit staff, court officials, and others subject to the judge's direction and control to do so. And then it points out that that doesn't preclude proper judicial consideration when race, sex, religion, and so forth are factors in the proceeding, which seems like it would have gone without saying, but the commentary requires judges to demand the same of lawyers practicing before them. A judge must refrain from speech, gestures, or other conduct that could reasonably be perceived as sexual harassment and must require the same standard of conduct of others subject to the judge's direction and control. That's really the only official limitation in Virginia on a lawyer engaging in conduct that manifests bias or prejudice. Virginia State Bar does have a diversity conference that was established in 2010, brings together bar members interested in promoting diversity and inclusion in the legal profession. They hold an annual forum on diversity in the legal profession. I've seen some of the materials and it looks like good stuff. And their goals, their stated goals are shown here: increase diversity and inclusion in the legal profession, maintain the quality of legal services in Virginia, increase diversity and inclusion at all levels of the judiciary, increase advancement of diverse individuals in the profession, increase involvement of diverse lawyers in the Virginia State Bar governance, and provide a forum to assist the profession and judiciary in addressing the legal needs of a diverse population. So that's what Virginia is doing. New York. I'm gonna go through every state here, by the way. New York has adopted a modified version of Rule 8.4D, the older one, but has not adopted the broader language of 8.4G, comment 3, or comment 4. So New York's Rule of Professional Conduct says that a lawyer or law firm shall not unlawfully discriminate in the practice of law, including in hiring, promoting, or otherwise determining conditions of employment on the basis of any protected status. Where there is a tribunal with jurisdiction to hear a complaint, if timely brought, a complaint based on unlawful discrimination shall be brought before such tribunal in the first instance. I think that's, if you could come up with a decent rule, an ethical rule, I think that's a reasonable provision to say, if what we're saying is unethical, it's also unlawful, and someone files a lawsuit or brings a complaint to have that conduct found unlawful, then we'll let that process play out first before we do the ethics thing. But this isn't much of a rule. That would be reasonable if there was really any meat to the rule. So the rest of it just talks about how you can prove that somebody has been found to have engaged in unlawful and also unethical activities. New York has similar rules of judicial conduct as Virginia. I won't read the whole thing. So judges are subject to rules that while they're at work, they can't manifest bias or prejudice outwardly. And even when they're off work, they can't hold membership in organizations that practice invidious discrimination on the basis of any protected status. And it says that they have to require lawyers, while the lawyers are in court at least, subject to the judge's control, to refrain from manifesting by words or conduct bias or prejudice based upon any protected status against parties, witnesses, counsel, or others. That's a little bit broader than the explicit restrictions in Virginia. New York State Bar also has a committee on diversity and inclusion to promote and advance full and equal participation of attorneys of color and other diverse attorneys in the New York State Bar Association in all sectors and every level of the legal profession. That committee hosts events all year long, and they've created a managing partner and attorney toolkit on fostering a diverse and inclusive work environment, which I think is a good thing. I think that's a good idea. You know, you're telling people you want them to do this. I think it's a good idea to give them some tools to use. You know, if nothing else, to inspire thought on the topic. So let's talk about, I know you're sitting there wondering, I wonder what it's like in the United Kingdom. So I thought I'd go ahead and answer that question for you. So I thought I was just curious, so I went and looked to see, they have a similar legal system, and I wondered what they did over there. So they have, you know, in England, they have the solicitors and the barristers, and each one has its own regulatory authority. So the solicitors' regulatory authority they have a code of conduct that emphasizes the importance of encouraging equality of opportunity and respect for diversity. And that duty expressly extends to recruiting legal services to clients and treatment of third parties in connection with client matters, encouraging the duty to encourage equality of opportunity and respect for diversity extends to all those things. This is not just prohibiting conduct, this is actually mandating conduct to some extent. It establishes what they call mandatory outcomes: avoiding unlawful discrimination, victimization, or harassment, providing services to clients in a way that respects diversity, making reasonable adjustments to avoid imposing burdens or costs on individuals with disabilities, ensuring that recruitment and employment practices encourage equality of opportunity and respect for diversity, and dealing with complaints of discrimination promptly, fairly, openly, and effectively. And it requires that those values be embedded within the law firm and that the law firm partners adopt policies to promote them. Compared to what we have, the ABA model rules, and in most of our jurisdictions, that's pretty strong. So what about the barristers? They have adopted equality and diversity rules as part of their code of conduct. And it requires that barristers' chambers have in force a written statement of policy on equality and diversity and a written plan implementing it. Where they have to have an equality and diversity officer. They have to have training in fair recruitment and selection. They have to have recruitment and selection processes that use objective and fair criteria. They have to have fair distribution of work opportunities and an anti-harassment policy with a procedure for addressing complaints and a policy aimed at supporting individuals with disabilities. I think we could use that as a model, not for where we ultimately want to be, but there are some good ideas there, I think, and if they can do it in England, I don't know why we can't do it here. But so over the years, we've tried to get people interested in diversity first with, and by the way, this right here, I'm starting to talk about the David Douglas and the presentation that he did and some other work that he's done, plus just some things that I've come up with over the years. We started out, we had diversity because it's the right thing to do, diversity and inclusion. That did get a lot of traction, so we started emphasizing the business case for diversity and inclusion. Clients want it, and so we need to do it for clients, and that works when clients want it. When clients demand it, it works. It often has negative consequences for the individuals involved, because some client says, I need to see diversity in my staffing of this matter, and a firm doesn't have any diversity, they're going to have to drag whoever could increase their diversity off from work that they may enjoy doing and want to do, and away from people they enjoy working with, and get them, reviewing documents or something to make this one matter look more diverse. But I appreciate the intent behind it. So the business case, we actually did at Wiley years ago. We were doing one of our 3-year plans, diversity plans, and we went and really dug deep into what clients were demanding. And we expected to find lots and lots and lots of clients making these kinds of demands, and we didn't find that much, but they are out there, and they are growing. And when that exists, as I said, you can get people interested in diversity and inclusion, but as soon as it doesn't exist, those people kind of lose interest. So I have thought, and since I did this presentation, to make an ethical case for diversity and inclusion. I think it is a moral obligation. I think it is an ethical obligation. I think it is our obligation as lawyers, as members of this profession, to do justice in our own workplaces. I think we have to do justice for each other and show justice toward each other, and I think that's the right thing to do. I think it's the good thing to do. I think it would be good for all of us, and I do think that we have an obligation to do that. But now we're talking about an ethical cases and rules of ethics, and as you've seen, there's not a lot there. I think we can all agree those rules that we have, to the extent they've been adopted, are better than nothing. I think we can all agree that nothing shouldn't be the comparator. They should be better than a lot of things, and we have a lot of room to go. So David Douglas says, when addressing this, making an ethical case for diversity, he says, ethics are different than morals because they are externally imposed codes of conduct. They can be codified and enforced, and they invoke shared values and professional responsibility to create these rules. And I think that's exactly right. The preamble, this is not totally out of thin air. The preamble to the Model Rules of Professional Conduct already says a lawyer, as a member of the legal profession, is a representative of clients, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. And that obligation, David Douglas suggests, and I agree, translates into a professional duty to undertake affirmative steps to remedy discrimination, eliminate bias, and promote equality, diversity, and inclusion in the legal profession. Now I'm going to show you David Douglas, I guess he came up with it on his own. I don't know, maybe he worked with somebody else, but has proposed a new Model Rule 8.5 that I think is brilliant, because I think it's enough of a reach that it's something worth working for and something you'd feel good about achieving, but it's so eminently reasonable. And he explains the basis for it, rising out of, we started requiring people to do, or encouraging people to do pro bono work, and we have the suggested 50 hours of pro bono work, and now why not diversity and inclusion? So here's his Rule 8.5. It starts off with the information from the preamble about our ethical obligation to promote the ideal of equality for all members of society. And it says that every lawyer has a professional duty to undertake affirmative steps to remedy de facto and de jure discrimination, eliminate bias, and promote equality, diversity, and inclusion in the legal profession. And the reason for that affirmative obligation is because there is so much implicit bias that even if we are to get a rule that outlaws us actually engaging in discrimination, that's not going to fix the problem, because so much of our problem is implicit. It's people not even really realizing what they're doing. And the rule would go on and say every lawyer should aspire, not mandated, aspire to devote at least 20 hours per year to efforts to eliminate bias and promote equality, diversity, and inclusion in the legal profession. And as David points out, we say exactly that same thing about pro bono, but it's 50 hours. So this is eminently reasonable. And then it goes on to talk about the kinds of things that you could do to satisfy your 20 hours per year. I think this is a great proposal. I'm actually going to talk to him and see if anybody's ever done anything with it. And if they haven't, maybe we should.